Now that he's on the other side, he has to be humble.
Oh, that's gonna be tough. Yeah. Oh, man. You're right there, Joe. Right there. Yeah, right. Shouldn't we? No, of course not. No. Joe, gets me out if I can pull something. Although I did have to do the
So,
SBC.
do you think weather is that bad? Do you think
I was just saying
tighten things up a little bit?
that's I know my eyes got like he just started laughing. He said, yeah, you know, it depends. It's all discretionary. Needless to say, Joe Goggins got the best average of all. My God, I don't know what Professor Goggins does. His students are all getting A's. It's amazing.
I had to take hormones to reduce my testosterone when I was sick.
Man, I'm telling you.
Okay. You should probably have a
What did you do? Now, did you just take medication? Did you have seeds? Did you have surgery? My father, I have it in my family. My father has it, my uncle has it. I'm Joe. I never did. I said to everybody, I said, he's too nasty to die. I said, Joe, no way. And they'd say to me, oh, you want to see Joe? He's got such a great personality. He's happy. I said, no, don't believe a minute of it. He made some deals, the fucking devil. He's acting like he's changed, but he hasn't. Believe me.
sit right there. You can face this way.
I was worried for him. I'm glad it worked out.
Hey, it changed. Your perspective face.
Okay, so
I've never been
Kevin,
happy.
you need to
No,
get
you look
Kevin
good,
wired.
Joe. You look good.
Your wife for sound guy.
Oh, really? I never did have to be wired.
Cross-examination.
I've never been
There's
wired.
Sean,
Look at this.
Joe Wagon. Nice to meet you. Thanks so much for doing this.
Cross-examine him.
Appreciate it. We put you right there in the corner seat there where the mic is. Screen it. Hold it in your pocket, put it in your belt.
Good.
So we'll seat Sean over here.
Yeah, that'll be council table, and hopefully we'll have a judge.
Yeah.
Copy.
I'll just let people know that we're gonna try.
Oh, is he, Sandra? Will you please? You're in a bad mood, I have to tell you. Martha Sassman was ugly. She was like, oh my God. I didn't get a chance to do the hi, how are you? And it was like, can you tell me? And I'm like, oh boy. But that's okay. Hey, what the heck?
Fine, okay, thank you. And what's the question? That was it? Oh, that's easy. Okay, fine. No problem. I'm typing the motion today. I already left
Would
it.
you like to be promoted?
Okay, and I'll knock it up.
Yeah, if I have to.
Which one? The next one.
Lost on the fourth floor.
Kevin is, you gotta give Kevin a space.
I'm reading the problem.
Reading the problem for the first time. Okay. Carol?
We're gonna get started, and as soon as we get a judge in here for the session. But I just wanted to tell you, we're gonna try to expedite the schedule a little bit, shorten up on some of the discussion, because we've been told that I guess the weather conditions have not gotten much better out there. So the school is gonna close early, and we're trying to get you all out a little bit earlier if we can. So bear with us, and we'll just try to move it along. Thank you.
This is this section is the hands-on type of section of the program. And we've done is put together as fair and neutral a fact pattern, as balanced a fact pattern, so we can see the advocates at work. That's really what this is all about, is advocacy. And you have to picture yourself in the role of defense counsel on this. We have very experienced judges. Judge Coffey will preside and rule on objections. Question is, will the advocates object, whether they should object, even if they have the right to object? These are some of the things that you keep in mind. So, and we've handpicked these people as models as to how to do these things. I think Kevin is reading the police report for the first time, but he's always visually prepared. So what I'd like to do is have you focus on the advocacy skills and not the case itself, and see if you can pick up some pointers on how these things are done, and then we'll have a little chat about it at the end of the demonstration. Sandra?
Commonwealth calls Officer Sean Sheehan to the stand. Officer, could you introduce yourself to the jury and state your name for the record?
Patrolman Sean Sheehan of Concord Police Department, SHEEHAN.
How long have you been with the Concord Police?
Approximately 10 years.
Do we have a microphone for Officer Sheehan?
Approximately 10 years.
In the course of your 10 years with the Concord Police, have you had any specialized training in the investigation of alcohol-related motor vehicle crimes?
OUI training, specifically field sobriety testing.
And with respect to that testing, how long ago was that?
Approximately 10 years ago.
Have you kept up to date with respect to advances in field sobriety testing or alcohol-related training?
Yes, I have.
And approximately, in the time that you've been a Concord police officer, how many arrests would you say you've made regarding operating under the influence crimes? During the time that you've been an officer with the Concord Police, have you had the opportunity to conduct a number of investigations with respect to motor vehicle crimes?
Yes.
Were you working on March 1st of 2002?
Yes, I was.
What shift were you working?
The midnight to 8 a.m. shift.
And were you alone at that time?
I was, yes.
Were you in a cruiser?
Yes, I was.
And where was the cruiser located?
Bedford Road in Concord, public way in the city of Concord.
Can you describe the area where you were located?
It's
Can I just note, I normally would object at that point.
The dead viewer, when the judge looked at it.
Just seeing if you're awake or asleep.
Yeah.
But for the purposes of expediency, can you describe that area?
there are 4 lanes, 2 lanes going east
There's
to.
stipulation that the road in question is a public way.
No.
No.
Okay.
Can you describe the lighting conditions in that area?
There are lights at the intersections of various roads intersecting with Bedford Road.
And who has access to that road?
The public?
Are there speed zones posted in that area?
Yes, there is.
What is the speed zone that's posted in that area?
45 miles an hour?
And the area is paved?
Yes.
Do you know who maintains that road?
The city of Concord?
And the particular road that you were on that night was?
Bedford Road?
Now, at approximately 2:24 in the morning, do you recall what you were doing?
I was parked in Tracy's tow lot.
And did you make any observations at that time?
I did, yes.
What did you observe?
A black motor vehicle traveling east on Bedford Road at a high rate of speed.
Can you approximate the rate of speed?
Approximately 30 miles over the speed limit.
And were you able to determine at that time how many individuals were occupying the car?
I was, yes.
How many?
1.
What did you do at that point?
I entered the roadway and followed the vehicle.
And approximately how far did you follow the vehicle?
Approximately a mile.
Did you make any observations of the car while you were following it?
I did, yes.
And what did you observe, officer?
It changed lanes on 2 occasions without using its turn signal.
Now, what did you do at that point?
At that point, I illuminated my blue lights, overhead blue lights, and turned my siren on and effected a stop of the motor vehicle.
Did the car stop immediately?
No, he did not.
Approximately how long did it take for the car to stop?
Half a mile.
And when the car was stopped, what did you do?
I exited my motor vehicle and approached the driver's side of the motor vehicle.
And at that time, did you have the opportunity to take a look at the individual who was driving?
I did, yes.
Do you see that person in court today?
I do, yes.
Can you point him out and identify a piece of clothing he's wearing?
He's wearing a tan suit right there.
I would ask the record reflect that the witness has identified the defendant.
Yes.
What were the initial, did you make any initial observations as you were approaching the car?
I did. I noticed a strong odor of alcoholic beverages coming from the interior of the vehicle. I noticed that the operator's eyes were glassy and bloodshot.
And did you make any other observations about his appearance or his demeanor?
No, I did not.
Could you describe the operator on that day? Approximately what he was wearing, height?
He's wearing well, I couldn't approximate his height because he was still in the car, but he was wearing a long sleeve shirt, approximately 40-ish, 40 years of age.
And did you have a conversation with that individual?
I did, yes.
As part of that conversation, were you able to identify who was driving the car?
I was, yes.
And who was that person?
Michael Oakstein.
Did you have a further conversation with Mr. Oakstein?
I did, yes.
And what was the nature of that conversation?
I asked him to produce his license and registration.
Did he produce his license and registration?
Initially, he didn't. I had to ask him a second time for it.
And when you asked him for his license and registration the second time, did he provide that for you?
Yes, he did.
What did you do at that point?
At that time, I asked Mr. Oakstein to exit the vehicle to perform some field sobriety tests.
And what was the reason for asking him to exit the vehicle?
The smell of alcoholic beverage coming from the vehicle, the fact that he failed to produce his license initially, those were the particular reasons.
Did you have any conversation with Mr. Oakstein regarding alcoholic beverages that night?
I did, yes.
And what was that conversation?
I asked him if he had had any alcoholic beverages during the evening, and he stated that he had two. He had a couple. Sorry.
What did you do at that point?
At that point, I took him out of the vehicle, asked him to exit the vehicle, and perform field sobriety tests.
Did you make any observations of the defendant as he was exiting the vehicle?
He was unsteady on his feet. He used his right hand to steady himself on the vehicle as he was getting to the front of the vehicle.
Now, can you describe the area where the field sobriety tests were to be conducted?
It's a breakdown lane of Route 2. It's a paved area, accessible from obviously Route 2, Bedford. Flat, level area, lighted by the takedown lights of my vehicle.
And approximately how wide was the area in which you were, which field sobriety tests were to be performed?
Approximately 10 feet.
From the road?
Yes.
Were there any other cars on the road at that time?
Not at that time.
And what were the weather conditions at that time?
It was cool. It was a little windy. Approximately 28 degrees.
28 degrees. And were you dressed in winter uniform at that time?
I was, yes.
And the defendant was wearing a long sleeve shirt, you stated?
That's correct, yes.
What were the, was anyone else present while these field sobriety tests were performed?
During the course of my field sobriety test, Officer Brophy showed up as a backup.
And is there a specific procedure that you follow in administering field sobriety tests?
There is, yes.
What's that procedure?
I asked the individual if he's on any medication or he has any medical problems that would inhibit his ability to perform the tests.
And did you ask Mr. Oakstein those questions that night?
I did, yes.
What were his responses to those questions?
No, he did not have any medical conditions or he was not on any medication.
And what do you then do when you're administering field sobriety tests?
I give instructions to the individual on how to perform the test.
What test did you request that Mr. Oakstein perform that evening?
4 tests. I had him do the recite the alphabet. I had him do the 9-leg walk and turn test. I'm sorry, 9-step walk and turn test. The 1-legged stand test and the finger to nose test.
Going through each of the tests, we'll start first with the alphabet test. Did you explain the procedure to Mr. Oakstein?
I did, yes.
Did you ask him any questions with respect that were particularized to that test?
Just specifically if he had any medical conditions that would affect his ability to conduct the test.
And did you inquire as to him as to what his level of education was?
Yes, I asked if specifically what his level of education was.
And what did he respond?
College education.
Did you demonstrate the test to him?
I did, yes.
Did he appear to understand your demonstration?
Yes, he did.
And how did he perform on that test?
He started the alphabet, and he stopped at D, and he started over.
Did you make any observations of his physical person while he was performing that test?
He was unsteady on his feet. He was talking in a slurred, thick-tongue manner.
And you stated that he started and got to D and started again. Was he able to complete the test on the second try?
Yes, he was.
And was there anything with respect to the completion of that test that was brought to note by you?
No.
Did you have any conversation with Mr. Augustine following that test?
Yes.
What was that conversation?
He stated to the effect, basically, what do you think of that?
And what was his manner in making that statement?
Belligerent, to the point.
Did you ask him to perform any other field sobriety tests that night?
I did, yes.
And what were those tests?
I asked him to do the finger to nose, tip of the finger to the tip of the nose test.
And how did you again just demonstrate that test, Mr. Oakstein?
I did, yes.
Did he appear to understand your demonstration?
Yes, he did.
Did you physically demonstrate the test as well as verbally?
I did, yes.
And how did he perform on that test?
When I instructed him to point his the tip of his right finger to the tip of his nose, he did that, and then I instructed him to point the tip of his left finger, his index finger, to the tip of his nose. He pointed to the top of his lip, and then I again asked him to use his right hand to the tip of his right index finger, and he pointed to his lower lip, and then I instructed him to use his left hand or the tip of his left index finger, and he touched the top of his lip.
How many attempts in all was Mr. Oakstein given to complete this test?
4.
And of those 4 attempts, did he complete any of them successfully?
Yes.
How many?
1.
Did you ask him to perform any other tests that night?
I did, yes.
And what was that test?
The one-leg stand test.
And can you describe to the jury what the one-legged stand entails?
You give the individual the opportunity to stand on either leg.
And why is that?
In case they feel better on one leg than on the other. And they're to raise the other leg 6 inches off the ground with the tip of their toe pointed straight forward, to look at their toe, and to count until I tell them to stop. And they have their hands at their side.
And what is the purpose of that test?
It's to test motor coordination, balance, ability to follow instructions, short-term memory.
When you explained the test to Mr. Oakstein, did he appear to understand your explanation of the test?
Yes, he did.
And how did he perform on that test?
When he raised his left foot 6 inches off the ground, he moved it back and forth in a manner to gain balance, and did something else too.
I'm sorry, I didn't hear that.
He raised his left foot off the ground and moved it back and forth, and then he used his left, and then he put his left foot up against his right foot to gain balance on numerous occasions.
It was the last mumbled part I didn't hear. I don't know if he said anything.
Could you repeat that again?
No, I don't believe he did.
Okay.
You can ask another question.
With respect to the position of Mr. Oakstein's arms, did you make any observations?
He used them in a flapping motion to gain balance.
And what leg was this test performed on?
He stood on his right leg and he put his left leg in the air.
In your opinion, did he pass that test?
No.
Overruled.
In your opinion, officer, did Mr. Augustine pass that test?
No, he did not.
Did you ask him to take any other field sobriety tests at that point?
I did, yes.
And what test was that?
The 9-step walk and turn test.
And what is the purpose of that test?
To test motor coordination, the ability to follow instructions.
And could you explain to the jury essentially what the 9-step walk and turn entails?
What it is, I instruct the individual to put his right foot in front of his left and to take 9 steps, heel to toe, with his hands by his side. And when he gets to his 9th step, to keep the front foot on the ground and to make a circular turn using small steps with his other foot, and to take 9 steps the other way, all counting aloud.
Officer, could you demonstrate that test briefly?
Yes, I could.
With the court's permission?
Yes.
I have the individual stand with his right foot in front of his left, his hands to his side, and I have him take 9 steps heel to toe, counting aloud. 1, 2, 3. And then when he gets to his 9th step, I have him take a complete turn using his other foot, keeping his left foot on the ground. Take 9 steps heel to toe in the opposite direction. 1, 2, 3.
And these tests were all conducted in the breakdown lane of the road?
That's correct, yes.
And how wide was that area?
Approximately 10 feet.
During this time, the time that the field sobriety tests were performed, approximately from start to finish, how much time passed?
20 minutes to a half an hour.
Now, during this time, was there heavy traffic on the road? Was there any traffic?
No, there wasn't heavy traffic. There was no traffic, actually.
And what observations, while Mr. Augustine was completing the 9-step walk and turn test, what observations did you make?
He used his arms for balance, and he was unsteady on his feet. He talked in a slurred, thick-tongued manner.
Was he able to maintain his balance throughout the test?
No, he was not.
At what point did he lose his balance?
When he was taking the steps, he used his arms for balance.
Based on your observations at that point, your conversation and the results of the field sobriety tests, were you able to form an opinion at that point as to the state of defendant's sobriety?
Yes, I was.
And what was that opinion?
That he was operating under the influence of alcohol.
What did you do at that point?
I placed him under arrest.
Okay,
Thank
we'll
you.
assume that all the rights were given, et cetera. Thank you, Sam.
Is that it?
Great.
How many years you been a police officer?
10 years.
In the same department?
That's correct, yes.
And when you first were in the academy, you went to the academy, right?
Yes.
You study things about how to be a police officer, how to investigate crimes, how to perform investigations on motor vehicle offenses, right?
Yes.
You go to the police academy to do that.
Yes.
Did you go to the academy?
Yes.
You study from books, just like somebody would study from books or manuals in college, or?
Yes.
And one of the things that you actually learned, or one of the things that you focused on, would be what you've referred to as field sobriety tests, right?
Yes.
And one of the things that you learn as a police officer is that it's important, number one, to try to be as accurate and as objective as humanly possible before you place someone under arrest. Is that fair?
Yes.
You try to keep an open mind.
Yes.
You try to fully and fairly investigate the case that you're investigating.
Yes.
Do you take notes when you're out there on the street?
I do, yes.
And on this occasion, did you take notes?
I did, yes.
Do you have them?
No, I do not.
Where are they?
They're in my, in the station.
In the station?
Yes.
All right. Have you given them to the district attorney at all?
Yes, I did.
We'll leave that.
Yeah.
All right.
Formal testimony is I destroyed them as soon as I wrote my report.
Usually it's the destruction issue, right? Now, when you're out there and you're interacting with a citizen, what you try to do is you try to be objective. You are looking for certain things that will allow you to form an opinion. Is that correct?
That's correct, yes.
And occasionally you'd be out there looking to form an opinion as to whether somebody's under the influence of alcohol, right?
That's correct, yes.
You know that if they're, in your opinion, under the influence of alcohol, then you're going to arrest them, right?
If they're operating a motor vehicle.
In your opinion.
Yes.
Yes, and as a result of your opinion, the person will then find himself or herself in court on trial, and you're testifying, right?
Objection.
Overruled.
Now, the evidence that the government has in this case consists of a videotape of the defendant and how he appeared that night?
Not as far as I know.
Okay, all right, let me back up. On this occasion that evening in the police station, did you have, as a police officer, knowledge of the ability to make a videotape?
Yes.
And you did, in fact, have not only the knowledge and the ability to videotape, but it's your discretion or choice as to whether or not you would so videotape. Is that fair?
Objection, Your Honor, not the booking officer.
I'm not asking about the booking officer, Your Honor.
Rephrase the question.
Sure. When we come into court, what we're dealing with would be your ability to tell a jury what your opinion is based on observations, correct?
That's correct, yes.
And you would agree that a videotape, for example, would really be very, very good, accurate evidence of what you yourself saw that evening, true?
Sure.
And it would be very cheap, I mean, it's not an overly expensive process for you to stand there like on a barbecue in the backyard and take a videotape, right?
I don't know what the cost is.
Well, you certainly know how to run a video camera.
Sure, yes, I
And you
do.
certainly made a decision, I guess, that it wasn't something you were going to do that evening.
It wasn't my decision.
All right, so you're the arresting officer.
Yes.
You're the officer in charge of this investigation.
Yes.
And on this occasion, if I heard you, you're correct with this, about what, 2:20 in the morning?
That's correct, yes.
This is a Saturday night, Friday night, Saturday morning, was it?
I don't recall.
You started working at what time?
Midnight.
And you're solo in your own cruiser.
That's correct.
And if I understand, you're on a routine cruiser patrol, right?
That's correct, yes.
Well, were you in fact on a patrol driving down the street when you made your observation of Mr. Oxteen initially?
No.
Were you stopped in a speed trap?
No.
Where were you stopped?
I was stopped at Tracy's parking lot on Bedford Road.
All right, and Tracy's parking lot on Bedford Road, you've already described it. It's kind of like a straightaway in your town, isn't it?
Bedford Road?
Yeah.
Yes, it
It's
is.
got a 45-mile-an-hour speed limit, right?
That's
It's
correct.
pretty good pickings for somebody driving or speeding along the highway or that roadway, right?
Objection.
Rephrase the question.
All right. On this occasion, you're there in Bedford Road. If I understand that you're parked stationary in the Tracy's Towing parking area, right?
That's correct.
Now, while you're parked stationary, no other brother or sister officers with you, right?
That's correct.
You're by yourself, right?
That's correct.
Windows up, right?
I don't
Cold night,
recall.
wasn't it?
It was a cold night.
And you're wearing your leather jacket,
Winter uniform.
winter uniform, because it's cold, and you have to have, obviously, clothing on, right?
I
For the
was
weather
in-
conditions.
I had my winter uniform on.
So you're sitting in the car, window up, heater on, right?
I don't recall.
And you're looking out the window at no traffic on the roadway, right?
I didn't see any traffic, no.
All of a sudden, along comes Mr. Oxteen, right?
That's correct, yes.
And while you're sitting there, you observe this vehicle traveling easterly on Route 2, that road we just described, at what you've indicated to the court would be a high rate of speed in your opinion, right?
That's correct,
Now, you didn't
yes.
hear any engine noises, did you?
I don't recall.
You observed the vehicle coming from what, your right to the left?
From my left to right.
Using seconds as an estimate, how many seconds did you have the vehicle in your observation, coming from that direction, heading in that direction?
Maybe 3 seconds, 4
3
seconds.
seconds, you observe this vehicle go from here to there, and your blue lights are on, right?
No, that's not correct.
Well, the vehicle passes by you, right?
That's correct.
And you didn't make any observation of the vehicle at that time while you were watching it, in those 3 seconds coming from this direction to that direction, going over lines, right?
That's correct, yes.
And the vehicle, obviously, was speeding, according to your investigation. Is that correct?
My estimation, the vehicle was operating 30 miles over the speed limit
So,
approximately.
well, you don't know how many miles over the speed limit he's going, right? You have an opinion he's speeding.
Yes, that's correct.
As a result of your observations, you then pull out of the parking area and begin traveling eastbound on Route 2, right?
That's correct, yes.
So as a result of those observations, your cruiser pulls out right behind him, correct?
Not right behind him, no.
How far behind him were you, sir?
I don't recall.
You certainly kept him in your observation.
I have, yes.
And Officer Brophy is now on his radio telling you that he observed the vehicle. You know which vehicle he was talking about, didn't you?
He stated that he had clocked a black vehicle traveling easterly on Route 2.
Right. And Brophy was parked stationary as well, doing the same thing you were, sitting there watching whatever.
From my recollection, he had a radar unit.
So Brophy was working a speed trap then.
I don't recall.
Was Brophy on one side of the street and you were on the other? You know, kind of like an intersecting force?
He was opposite from me, yes.
So Brophy's opposite from you. He's working a speed radar. Brophy communicates with you on the radio, and both of you are following Mr. Oxteen, right?
My initial indication was that he was speeding.
I just
Subsequent,
asked you if you were following him. That's
I
both of
was I was behind him,
you.
yes.
All right. Both cruisers are now behind him, right?
No, that's not correct.
Did Brophy get behind your cruiser?
No,
Did you follow Mr. Oxteen?
I did, yes.
And at some point, did you indicate to Officer Brophy that you were traveling eastbound and that you were now on the flats?
Indicate to Brophy? No.
Okay? The flats are an area of the town that's known for drag racing, right?
Not as far as I know.
All right, but nevertheless, you followed the vehicle, correct?
Yes, that's correct.
You told us that you followed the vehicle for about, what, a half a mile?
No, after I initiated my blue lights, overhead blue lights and siren, it took him a half a mile to stop.
I didn't ask you if it took him a half a mile to stop. My question was, did you follow him, according to your testimony, for a half a mile?
I don't recall.
Do you remember using the terminology a half a mile?
Yes.
Could it have been more than a half a mile that you had Mr. Rockstein's vehicle in your sights before you put on your takedown lights?
Before I put on my takedown lights? I don't understand the question.
Okay, car goes by, you follow car, finally you put your blue lights on, true?
Yes.
What's the distance we're talking, sir, from the time you first follow Mr. Rockstein's car to the time you put on your blue lights?
I don't recall.
More than a half a mile?
I don't recall.
So from whatever it is, sir, that your memory is that you followed this vehicle, is it your testimony that that vehicle only on, I guess, one occasion went from one lane, if I understand correctly, to the lane next to it and back? That's your testimony, right?
The vehicle did travel from one lane to the next lane and to that
Once.
lane back.
Once.
Twice.
Okay, so in that entire distance that you're following this vehicle, you've got it in your view, it's not going over the lines other than what you just told us, true?
That's correct, yes.
And you're in a marked cruiser, right?
Yes.
And you're behind this vehicle, what, couple of car lanes?
No, that's not correct.
And while you're following behind the vehicle at whatever the number of car lanes it is, there's not another soul or car on the roadway, right?
That's correct, yes.
You observe this vehicle pull over and then pull back into the lane and you continue to follow him, right?
That's correct, yes.
Finally, you put on your blue lights and your siren.
That's correct.
And the vehicle at some point continues to travel and for a half a mile, your observation would be, and now he goes into the neighboring town of Lexington, right?
He does, yes.
Did you call ahead and say that you were going to be stopping a vehicle in the sister jurisdiction?
No.
So you pull up behind the vehicle when he stops, right? He
I
stops
did,
his
yes.
car. He stops his car, he's on the right-hand side of the road, right?
Yes.
You don't make any observation that the rear end of the car is sticking out in the street or the wheels are up on the sidewalk. He parks it appropriately parallel, right?
That's correct,
You
yes.
park your cruiser a little bit to the left to allow yourself that safe passage up to the driver's side window, right?
That's correct.
Driver's side window is down now, true? You detect an odor, you're nodding your head.
Yes, that's
You detect
correct.
an odor of alcohol coming from the interior of the vehicle is your testimony.
That's correct,
You
yes.
agree that, on a cold night especially, there's a vacuum that forms inside the car, and when the window comes down, you learn that, you hear that. The interior of the vehicle air will then come out right at you.
I'm not aware of that. but
All right, so you ask him for a license or registration?
That's correct,
Did you
yes.
ask him where he was going, you know, where's the fire or something like that?
No, I did not.
You ask him to produce the documents, and I believe while you ask him that question, you were now going to wait for him to produce the documents, right?
That's not correct, no.
All right, you learn in the academy that you have different sequences of interacting with a citizen when you stop them, right?
That's correct, yes.
And one of the sequences is when you first approach and you ask them for their documents and how they produce them and where they get them from, right?
That's correct.
You heard the concept divided attention. You
I
learned
have.
that, right?
Yes.
In other words, you ask the person to say the alphabet and at the same time ask them to pick something up and just to see if they're able to focus not only on the dexterity but also on the intellect, right?
Yes, that's correct.
So you ask him to produce his license and registration, and you told the jurors that he didn't do it. It took him 2 times for you to ask him that, right?
That's correct.
Well, in fact, sir, isn't it true that what you did is that you asked him for his license and registration, you then detected the odor of alcohol, and you then asked him if he consumed any alcohol on that date, and he was answering you.
That's not correct, no.
You prepared a police report.
I did, yes.
Prepared it that night.
I did, yes.
Your memory would be pretty good then.
Then, yes.
And if I may, Your Honor, I'd like to just approach the officer. Is this your report, sir?
Yes, it is.
And just take a look at this and read it to yourself. Does this indicate the approach to the driver's side?
Yes, it does.
Does that indicate asking him for his license and reg?
Yes, it does.
Does it then state that you then had a conversation after smelling an odor of alcohol coming from him?
That's correct.
You
Coming
then
from the
asked him-
interior of the vehicle.
You then asked him a question,
That's correct, yes.
and he answered the question.
Yes, that's correct.
So, again, I ask you, you ask him for his license and reg, and you then ask him to answer some of your questions, right?
That's correct, yes.
And he did cooperate in the sense of answering your questions, true?
That's correct, yes.
Stated he had a couple of beers with dinner.
That's correct, yes.
And again, sir, trying to be fair and objective in your investigation. How many beers did he have that night?
He said he had a couple beers.
Yeah, but I mean, what's a couple? Is it 2? Is it 3? Is it, what kind of beer?
Objection.
Sustain, rephrase it.
Okay, you want to be objective and fair and find out whether or not the person's intoxicated, right?
That's correct,
Man
yes.
says that he had a couple of beers, right?
That's correct.
Where did he have the beer?
I'm not aware of, I do not know.
When did he have the beer?
I don't know.
Is that important to you, sir, to determine with a cooperating citizen who's answering your questions, where he had the beer, when he had the beer, what he had to drink, how many cans of beer, whether they were 12 ounce, 16 ounce?
No,
Not important.
no.
So at this point, sir, you then ask him again to get his license and registration, right?
That's correct.
And he does.
That's correct.
And he produces the license. He doesn't give you the BJ's card or something, right?
That's correct.
Where did he get the license from?
From his wallet?
No fumbling, no difficulty, true?
That's true, yes.
You then ask him for the registration, right?
Correct.
Now, these are things in the academy you learn the dexterity, right? You're watching for this, true?
That's correct.
And
yeah.
he did nothing wrong. He went in his glove box, he picked his documents up and handed them to you, correct?
That's correct.
At this point, sir, you made the observation, I believe, that you said his eyes appear to be bloodshot and glassy.
That's correct.
Now, you would agree with me, you learn in the academy that observations that you make as an officer, for example, you say slurred speech or thick-tongued or glassy eyes and things, can certainly be caused by other factors other than alcohol, true?
I'm sure that's possible.
Okay, what are some of them that you learned?
The weather.
The weather? Okay. How
Medical
about,
conditions.
What is it?
Medical conditions.
Okay. How about, for example, nervousness? When a person deals with a uniformed police officer with the blue lights going, you can be nervous.
Sure.
Thick-tongued person sometimes can be thick-tongued, confused, right?
Sure.
And, for example, glassy eyes, bloodshot eyes. If a person is coming from a lounge or a restaurant where people are smoking, that could affect it, couldn't it?
Sure.
So while you make the observations, and you never heard this man speak before, did you?
No.
Now, you then ask him, after he produces his documents, you make the observation, sir, of the speech on the fellow. You never heard him speak before, but nevertheless, you ask him to get out of the vehicle. And if I understand correctly, he exited the vehicle, and you noted that he was unsteady, and you made the observation that he put his hand on the side of the vehicle to steady himself.
That's correct.
Now, again, we don't have a video, but this is your memory, true?
That's correct.
Now, when you stepped down and counsel asked you to demonstrate the 9-leg walk and turn or the 9-step walk and turn, you held on to the corner of that table there. Were you having difficulty?
I don't recall.
All right. But, I mean, you certainly would agree that people many times just do that, will hold on to something like that? In fairness, I mean, you can do that, right?
It's your opinion.
All right. So you then ask him to walk to the front of the vehicle. You do make the observation of him walking. You ask him to conduct these, what you say are field tests, correct?
Field sobriety tests.
All right. Now, you would understand or agree with me that these are not really tests that somebody passes or fails as much as they're dexterity exercises. You ask a person to do something to observe their dexterity, right?
You don't pass or fail the test. That's
Right.
correct.
And so it's not really a test. It's something that you, as an officer, would ask the person to do that might be a little unusual, but it's dexterity you're watching and divided attention.
It's not unusual.
And the dexterity, sir, do you know what I mean by dexterity?
Yes, I
How
understand.
the person, and you're trying to see how the person, for example, walks, holds up a leg, does that type of activity, right?
I'm trying to determine their motor coordination.
Yes. And as you say, there are any number of things that can impair a person's motor coordination, right?
Well,
So
That's
have in mind the nervousness and have in mind the interaction with you. And by the way, at this point, the other police officer had already arrived, didn't he?
that's correct, yes.
So you have your, what do you call them, takedown lights on?
That's
And your-
correct,
And your
yes.
blue lights on, right?
My takedown lights are on, yes, and my reverse blue lights are on.
Your reverse blue lights. And the
Yes.
reason you say reverse blue lights is because you've learned in the academy and over the years, perhaps, that people get rattled by the blue lights. when they-
Objection.
Overruled, you may have it.
Fair to say?
Yeah, it's fair to say.
And for your own safety as well. I mean, you've got to have the ability to observe the person you're dealing with, right?
That's correct.
So the other cruiser arrives, and he has his, what, reverse blue lights and takedown lights on?
I don't recall.
So he gets out of the vehicle, his cruiser. Any other cruisers around?
No, that's it.
Both of you in uniform,
That-
flashlights that you're using, on the side of the roadway, right? Weather
That's correct.
conditions, you say, were, I think you said cool, but in fact, it was 28 degrees, wasn't it?
28 degrees, yeah.
Well, that's pretty cold, right?
Yeah, for some people.
And my guy is sitting in his car, and you ask him to get out of the vehicle, and he's wearing a shirt, right?
He's wearing a long sleeve shirt, yes.
He had a jacket in his car, didn't he?
That's correct.
He asked you if he could put his jacket on, didn't he?
He did, yes.
And you said no.
That's correct.
And nevertheless, you make the observation. And by the way, how much does he weigh? Did you notice that in the course of your interacting with him?
I didn't, no.
My understanding, sir, that it appears in the course of discovery that defendant is 5 foot 9 inches tall and he weighs 245 pounds. Would you agree that he appears to be a little portly?
No, I wouldn't agree to that.
Well, in any event, you certainly in the academy, you learn in your manual, and you have studied by the manual put out by the National Highway Transportation Safety Board and approved by the state police, right?
That's correct, yes.
Now, I may not have the particular manual that you actually studied from, but you do remember learning that the National Highway Transportation Safety Board has certain things that must be factored into the person's opinion when you ask somebody to perform these dexterity exercises, right?
That's correct, yes.
Such as, for example, a person's weight.
Correct, yes.
And if a person is 50 pounds or more overweight, shall we say, can certainly skew or affect a person's ability to stand on one leg, for example, right?
Well, that's your opinion, yes.
Certainly. Beg your pardon?
That's your opinion, yes.
Well, no, I'm not asking you my opinion. I'm asking you about the National Highway Transportation Safety Board's opinion, sir.
Yes.
Yes. And 50 pounds or more can certainly, according to the National Highway Transportation Safety Board, affect the person's ability to stand on one leg.
Yes.
Affect the person's ability to walk, you know, doing like this, where you walk with one leg in front of the other, right?
No.
Okay. Now, you would agree with me that when you ask him to recite the alphabet, he recites it up to D and stops, right?
That's correct, yes.
Now, you'd certainly, in fairness, would say a person could be nervous and confused, have a brain cramp, as they say.
He could be nervous.
Okay. So he stops at D and then starts again, though, right? Yes?
He starts again, yes.
So when he starts again, if I understand correctly, he says A, B, C, D, but you noted that he said it slowly and methodically, right?
That's correct, yes.
Now, you're a police officer. You got a guy on the side of the road, 2:20 in the morning. You're asking him to perform these exercises. Did you tell him not to recite it slowly and methodically?
I did not, no.
Oh. So he says A, B, C, D. I won't go through them all. But he goes from A to Z
He stops at D.
first time.
And he restarts.
Then he restarts, and he does it right.
That's correct,
Now, you
yes.
certainly at this point didn't have an opinion he was under the influence, being objective.
I hadn't formed an opinion yet.
Okay. So as a result of that, sir, you then ask him to perform the other exercise, which would be the finger to the nose, right?
That's correct.
You made your observations that he appeared to be swaying during the course of the test. Nevertheless, he kept his feet together as you instructed, true?
Correct, yes.
Did you ask him to lean back and close his eyes?
I did,
Did you
yes.
ask him to put his hands out by his side and then touch one and then the other?
I have his hands by his side, yes.
If I understand correctly, he never staggered back, as it were. He certainly didn't have to have you or the other officer in uniform catch him or anything, right?
That's correct,
He
yes.
didn't sidestep out into the street or anything, did he?
No, he did
He
not.
was standing with the two legs together, leaning back, eyes closed, and then he did, in fact, touch the first finger appropriately.
That's correct, yes.
You then observed him touch the other finger. I guess he was off by a half an inch or something on the tip of the nose, and then you observed him touch again with the right index finger, lower lip, and then upper lip.
That's correct, yes.
Did you say right, left, things like
I
that?
did, yes.
So he was appropriate in the response, right hand, left hand, that type of thing.
He didn't complete the test.
No, when you said right, did he use his right hand?
Yes, he did.
When you say left, did he use his left hand?
He did, yes.
All right. And at this point, again, having all these things in mind, you certainly wouldn't have an opinion he was under the influence of alcohol, did you, sir?
I hadn't formed an opinion.
And you're, of course, you're out there with your outfit on, you get your winter clothing on, you're out there for a significant period of time. You told us, what, a half hour, 20 minutes?
20 minutes to a half an hour for the
At
entire
28 degrees
for the
with-
entire test.
Very windy that night as well, wasn't
There
it?
was some wind, if I do
Okay.
recall.
And did you ever let him get his jacket at all?
I did not know.
You then wanted him to perform another exercise, and as you say, you know, initially the 9-leg stand, but of course it would be the 9-step walk and turn.
That's correct,
I mean,
yes.
that's understandable, but you then ask him to count the 9 steps out. You tell him how you want him to do it, right? You want him to count the numbers as well, right?
That's correct.
Now, if I understand correctly, you say that he used his arms in a flapping movement, and you observe that he placed his left foot on and off the inside of his, I'm sorry, that would be the one-legged stand. Which one?
One leg stand.
Is that the sequence of it? Was it the 9-step walk and turn, or was it the one-legged stand?
We did the one-step, the one-leg stand, 9-step walk and turn.
All right, and you remember that because you wrote it down, the sequence that you performed it?
Yes.
All right, so we'll do that. The one-legged stand for the count of 30. You tell him you want him to hold one foot up for what, 6 inches off the ground?
6 inches off the ground, yes.
Did he hold his foot up 6 inches off the ground?
He did, yes.
Yes. Did he count from 1 to 30?
He counted, yes.
Did he count sequentially appropriate?
Yes.
Did he jumble up the numbers?
No, he did not.
And by the way, you'd agree, sir, that you're again being objective and fair, a person having an injury could impair their
Objection.
ability to perform that test. He's already testified to that.
Overrule.
Yes?
I'm sorry?
An
Can you repeat the
injury could
question?
affect the person's ability to perform that test.
Yes, I suppose so.
Now, in evidence under Chapter 23379G, we have certified copies of medical records, sir, that show that this defendant, in fact, suffers from an unrepaired ACL tear in his right knee from a high school football injury that impacts the ability to stand on one leg. Yes?
I'm unaware of that.
Okay. But certainly, I mean, that could affect the person's ability to perform that particular exercise, right? The injury.
No, I'd say so.
Okay. So again, at this point, I mean, have in mind, he counts from 1 to 30. During that 1 to 30 count, holds his foot 6 inches off the ground. You certainly didn't have an opinion he was under the influence at that point.
I hadn't formed an opinion
All
yet.
right. So you asked him to do the 9-step walk and turn.
That's correct,
Yes?
yes.
And he counts 9 out. Counts out appropriately,
That's
9
correct,
steps. He does touch his heel to his toe.
Yes, he does.
He does get to, I guess you said that he appeared to be a little unsteady when he turned.
When he turned, yes.
Okay. And the numbers were counted sequentially appropriate.
Yes.
He then turns around and he walks back, as you asked him, the 9 steps, right?
Yes.
And he counts out again appropriately, doesn't he?
That's correct, yes.
And at that point, you talk to your brother officer, true?
That's not correct, no.
Well, he was standing there throughout the interaction with the defendant, right?
That's correct,
You
yes.
then placed him under arrest, didn't you?
I did place him under arrest, yes.
You let him get his jacket at that point?
No.
Thank you.
Good. Thank you, Sean. By the way, Sean is one of our law students at the law school. He also happens to be a sworn police officer of the city of Somerville. Dr. Baker, what I'm going to have you do is just hold your questions, because we're trying to compress a lot of stuff. But you will have the opportunity to ask Kevin and Sandra why they did certain things, make those and write it down. But this time, what I'd like to do is do a direct examination of the doctor as he would use a typical OUI case. Not a lethal homicide, the issue of the breath test. I don't speak loud enough? Okay, good, thanks. So, I'm going to ask the doctor a series of questions, and you all know how what the series would involve. You qualify the expert, and you just go on. You don't ask, at least I don't ask the judge for a ruling on his qualification unless there's an objection. I just make it a pro forma thing. Why wouldn't be an expert with all of these qualifications? And then I ask him to talk about how he was retained, what particular documents he studied, and then talk more specifically about the machine. Should I stand here?
Just make sure that's turning.
Okay. Don't you do anything? What's on? Can't hear me? Okay, thanks. Doctor, could you tell us your profession, please?
I'm a clinical pharmacologist and toxicologist.
And what is a clinical pharmacologist?
It's a scientist who studies the effects of drugs on people.
And what's a clinical toxicologist?
It's a scientist who's familiar with the adverse or negative or poisoning effects of drugs.
Can you describe your educational background?
Sure, I went to Newton High School, I went to Boston University, and I have a master's and a PhD from the University of Vermont College of Medicine in the field of pharmacology.
And could you describe your work experience?
Sure. After finishing my training, I worked in the pharmaceutical industry for 12 years, developing and testing new drugs, writing package inserts, assessing effects of drugs and toxicity, and filing those reports with the Food and Drug Administration in support of getting new drugs approved.
And do you have any publications, sir?
Yes, sir, I do.
And about how many?
A little over 175.
And are any of these publications involving the effects of alcohol on people?
Yes, sir, many.
Have these publications been presented in peer review in professional journals or proceedings?
Yes, they have.
They've been reviewed by your peers?
They have.
Okay. Have you completed any continuing education programs on the effects of ethanol on human performance?
Yes, sir.
And what were they?
I've done two, one in 1998 and one in 2000, and then I actually taught one course at the American Academy of Forensic Sciences 2 years ago.
And have you done any teaching on the effects of ethanol on humans?
Quite a bit.
And to whom?
I've taught at MCLE, I've taught at MATA, and I've also, for the last 5 years, been teaching circuit judges in the state of Florida on breathalyzer, blood alcohol toxicology, urine drug screening, and field sobriety testing. I also did a national program for the ABA and NHTSA in Rhode Island back in 1999, and that was for about 150 judges from around the country.
Do you have any academic appointments or teaching experience?
I do.
And what are they?
I'm adjunct assistant professor at Tufts Medical School, and I also guest lecture at the Harvard Medical School Risk Management Program, and I've also taught scientific evidence at George Washington University and medical jurisprudence at Stetson Law School.
And you're familiar with the case of Commonwealth versus Oakstein?
I am.
Did I retain you to get involved with that case?
Yes, you did.
And what did I ask you to do?
You asked me to review the police report and the results of the breathalyzer testing, and then to review the medical and toxicology literature on the variability involved with breathalyzer testing.
And did you review any information on how many drinks Mr. Oakstein claimed he had?
In the police report, it was stated that he had a few drinks.
Now I'm going to show, I've showed you a copy, you have in front of you a copy of the breathalyzer test result for Mr. Oakstein. Are you familiar with this test?
I am.
And what was the result of this test?
0.15.
1.5? Okay. Do you believe that this is an accurate and reliable representation of my client's blood alcohol concentration to a reasonable degree of scientific certainty?
No, sir, I do not.
Why not?
Because the breathalyzer does not measure blood alcohol directly.
What does it measure?
It measures the amount of ethanol in a certain population or size of expired breath air, and then it extrapolates based on that breath air to what a blood alcohol concentration might be.
Are you familiar with the particular machine that was used on Mr. Oakstein?
Yes, I am.
And how are you familiar with it?
Well, I've studied the machine. I've been involved with actually the use of the machine in administering breathalyzer testing. When I do the programs in Florida, we do them for the circuit judges, and many of the judges are involved with taking reasonable amounts of ethanol and then having their breath tested, and then also undergoing field sobriety testing.
These are like sober as judges? Is that the one?
Oh, they all are sober as judges, yes.
What particular machine are we talking about?
Well, we've used the Intoxilizer 5000 up to recently, and subsequently in that program we'll be using the Alka-Test 7110.
And the Alka-Test machine, was that the one that you used in the Oakstein case?
I believe it was.
Okay. And how does that work?
The machine works on two basic principles. The first is that when that person blows into the machine, the sample is split in half, and half is analyzed by an infrared absorption machine, and the other part is analyzed by what's called an electrochemical test. And what those do is those are parts of the machine that respond to the amount of ethanol in the expired breath sample and give you a reading based on that amount.
Then how does the machine reach a result that the Commonwealth claims is a fair representation of Mr. Oakstein's blood alcohol concentration?
The machine is programmed to use a ratio of 1 to 2100, and that means that the amount of ethanol in 1 milliliter of blood, and just to give you a reference point, a milliliter is about 1/5 of a teaspoon, and it then calculates to a ratio of 1 to 2100. That means that the amount of ethanol in 1 milliliter of blood would be the same as the amount of ethanol in 2100 milliliters of deep alveolar or deep lung air. And it uses that ratio to extrapolate from the size of the sample of air that's collected in the machine, and it takes that sample as, for example, if it were 70 milliliters, it would take that and multiply it by 30 to get to 2100.
Now, does the machine use the same 1 to 2100 ratio for all people?
Yes, it does.
Male and female?
Yes.
Big and small?
Yes.
You said, I believe, that 1 to 2100 was the average blood-to-breath ratio.
Well, it was considered the average for many years. It's now known that the true average in the population is closer to 1 to 2300 or 1 to 2400, but almost all the breath testing machines that are used throughout the United States use that 1 to 2100 ratio.
And does Massachusetts use that 1 to 2100 ratio?
It does indeed.
Okay. Do you know what the variability in upper and lower limits are?
Yes, sir, I do.
And what are those?
The variability for 99% of the population can be as low as 1 to 1500 or as high as 1 to 3100.
Now, 1500 to 3100, that's a range of how much?
About twofold, 200%.
Well, doctor, I want you to assume that my client had a blood-breath ratio of 1 to 3100. And the breath test registered a value of 0.15 when the machine was used at 1 to 2100. Can you calculate what my client's blood alcohol would have been under those circumstances?
I can.
And what would it be?
About 0.07.
Now, how could that be?
Because if you assume that the client had a ratio of 1 to 3100 and the machine was using a ratio of 1 to 2100, there would be about a 48% overshoot when you measure breath ethanol. So what you have to do is you have to take that 0.15 and reduce it by actually 52%. And when that would come down to a little over 0.075, and the Code of Massachusetts regulations instructs you to truncate to a 2 decimal mode, which means that the third decimal has to come off, so only 0.07 are appropriate.
Okay. Now, I want you to assume that Mr. Oakstein is 5'9" tall, and at the time of the test weighed 240 pounds, and that he drank 3 beers, beginning at 8 p.m., and he had his last drink at 10:30. Can you calculate what his blood alcohol would have been after finishing the drinks at the time he was stopped?
I can give you a reasonable estimate.
Okay. And can you explain how you do these calculations first?
Sure. In a man that size, each beer, assuming it's a 12-ounce beer,
12-ounce straight beer.
and a regular beer, which would have about 4.2% ethanol in it, that means that his blood alcohol would be way below 0.02, probably far closer to 0.015.
How do you make that computation?
You make that calculation using a formula called the Widmark formula, which is the generally accepted formula for calculating blood alcohol from a person's height and weight and the amount of ethanol consumed over unit time.
Okay, would you tell us how you do that?
Sure. You take the amount of ethanol that was consumed and you multiply that as the top part of the fraction by the specific gravity for both blood and for ethanol, and then you divide it by the person's weight converted to kilograms. So you said he weighed 240. You'd have to divide that by 2.2, which is the number of pounds in a kilogram. And then you have to multiply that by what's called the Widmark distribution, or the Widmark R formula. And for a man who's about 5'9" and weighs 240, he'd be a little on the chubby side. The normal number would be about 0.68, but for him it would be a lower number because he has a higher amount of body fat. Then you take the amount of ethanol that was consumed, you divide it by the body weight, and you subtract off the amount of ethanol that was burnt. You asked me to assume he had the first beer at 8 o'clock
Yep.
and finished the last one at 10:30.
Yep.
That's 2.5 hours. The burn-off rate averages about 0.02, so that's 0.02 times 2 is 0.04, plus another half an hour is 0.05. Each beer could not have been more than 0.02, so it's 0.06 minus 0.05. He would have had a blood ethanol of around 0.01.
By the way, I didn't plug it into our particular problem, but that's basically how you do it. The number of beers, the amount of time, the weight of the individual, and the time he blew into the machine. And then, if you want to get really fancy, the doctor can do what's called retrograde extrapolation to see what that number was back on the road, whether it helps you or hurts you. Doctor, in addition to the variability in the blood-to-breath ratio in the population, are there any other factors that could account for the elevated BAC reading from the breathalyzer?
Yes, there are.
And what are those?
Some of those factors involve the diameter of the mouthpiece into which you're blowing, the length of the tubing that connects the mouthpiece to the machine, the diameter of the tubing, the temperature of the expired breath, the temperature at which the machine was zeroed in and calibrated, the barometric pressure. All of those factors enter into the variability of the machine.
What about the age of the subject?
The age of the subject,
In terms of the ability to blow into the machine?
some of those things might be affected by age, but there are more intrinsic variability. You could have young people who couldn't blow very well, and you could have older people who could do fine.
Are you familiar with studies that address the concerns about the pressure that is used to blow into the machine and how the machine pressure can be adjusted?
Well, that would relate to the back pressure in terms of blowing into the machine, the resistance, if you will.
And do these studies reveal anything to you?
They do.
And what do they reveal?
They reveal that with that Draeger machine, the Alcatel 7110, there is a percentage of about 16% of those people who try to blow into the machine who are unable to supply an adequate sample.
Now, how about the variability of the calibration test? You familiar with the calibration test?
I am.
That's the so-called simulator solution that's used?
That's correct.
Okay, tell us about that.
The calculator or the simulator solution should be 0.15. However, the Commonwealth allows a tolerance of plus or minus 0.01. So if the calculator or the calculator check comes out to be 0.14, 0.15 or 0.16, that's an acceptable test. But that means that the intrinsic variability of the machine in being able to determine the ethanol content of the positive control or calculated check would be 0.01 over 0.15 or 1 over 15, and that means about another 6.5% variability as well.
So there's up to a 48% variability in the population of an individual's blood-to-breath ratio?
That's correct.
And again, tell us how you reach that number?
That number is based on the fact that if you assume an individual has a blood-to-breath ratio of 1 to 3,100 and the machine is using 1 to 2,100, the difference is really 1,000 units. You put 1,000 over 2,100, you can see that's almost half, so it's a little bit less. It's 48%.
Now, I don't know if you've already answered this, Doctor, but there's a variability due to changes in temperature and barometric pressure associated with calibrating the instrument at different times, and a set of circumstances as well as differences in breathing patterns, moisture and different lengths of tubing that you've already talked about with different types of mouthpieces. You're familiar with that?
That is correct.
And you're familiar with what they do in Massachusetts relative to this?
I am.
Okay. And that adds an additional variability, you said?
It does.
And how much is that?
10 to 15%, I would estimate.
Okay. And that's a total variability of how much?
Well, 48% from the variability in the population, up to 15% from that, which would be 48, 58, 63, and then another 6.5 or 7% from the intrinsic variability on the CalCheck, so it could be up to 70% variability.
I have no further questions. Now, I'm sure that a lot of this stuff And what you try to do with an expert like this is try to avoid the jury's eyes from glazing over. One of the problems that you have is earlier that morning, one of the jurors had a conversation at breakfast with a husband. And he said to her, Mabel, you're not going to understand a goddamn thing they're talking about. And sure enough, she's shaking her head. You're right. So what I have to do, and this is the reason I like Dr. Benjamin, and I use it myself, is he can break it down into its simplest parts so we can understand it. I've used several experts doing this type of work, as many of us have. And the goal is to make sure it's understandable. He might be absolutely correct, but if you don't understand it, it's wasted. So what I try to do is get the rhythm, get it over with, and I want them to remember a number, 65 to 70%. I want to be able to sell that number in final argument. That's the only number I care about, 65 to 70%. And the point is, how do you get there in a logical way? So you're going to be dealing with that. Why don't we talk about it? We have a panel here now, so why don't we discuss it? What is the reaction of these types of experts now in these courts? Judge, I'll have you.
I think there's a question.
Sir.
After you finish your direct,
Yeah.
it's all defense-oriented. How would he be cross-examined? Because I'm sure the Commonwealth wouldn't allow him to get away with it.
Commonwealth has to prepare and do it. I'm not going to ask Sandra to do it, but the Commonwealth will have. They will be on notice of an expert. We usually send over the qualifications.
But the number's not going to come out 65% after the Commonwealth proves it.
Not necessarily true. Don't say that, because most of the things that he's testifying about are not in that state police infrared breath test manual. They have things such as testimony on a Delbert motion down in New Jersey where they tested this exact same machine and had witnesses come on, including the president of the manufacturing company. And it's on record, and they can't get around that. It's wonderful stuff. That's why I said you can have a level of comfort if you hire the right expert who's done his homework. What did you do to find out this stuff?
Right, I'm glad you asked. This is not something I made up. This is evidence-based, and if you stay for my presentation towards the end, I'll show you the evidence base on it, because the variability, and actually this whole approach to attacking the variability in the breathalyzer, I developed because I gave a presentation to a bunch of forensic scientists at a meeting about 4 or 5 years ago, and my topic that was assigned was defenses in OUI, and what I had to do was go to the literature and find out what the actual variability was. And you're going to see how this applies to error rate from Darbert when I put up some of my slides. But this is all evidence-based. I always have those papers with me. If I'm challenged on it on cross-examination, I hand over a couple of the papers, and it's really irrefutable. Probably the best point that can be brought up on cross would be, well, doctor, you don't really know what that individual's blood-to-breath ratio is, meaning the assumption of 1 to 3,100, to which I answer, that's correct, and neither does the Commonwealth nor the machine.
Anyone else? Yes, sir. Keep your voice up so we can hear you.
Sorry. How does the defendant deal with that issue? When you're cross-examining, they say you never even met this defendant. You don't know what his ratio is.
Let me repeat the question. How does the defendant deal with this, and how do you deal with this when you might not have ever met the defendant or know the specific ratio? And how would you test for that kind of ratio?
Right. Well, I don't know how the defendant deals with it, because in many instances the defendant never even testifies, so it's not even an issue for the defendant. You can't tell what a person's blood-to-breath ratio is by their size. I mean, you could have Shaquille O'Neal in here, and you could have one of the fellows from the midget wrestlers or something, and you wouldn't know what their blood-breath ratio was unless you measured it. Now, how could you do that? You'd have to do a test, and what you'd have to do would be capture a sample of breath, capture a sample of blood, analyze them both with a gas chromatogram, and look at the difference between them. And that's not even feasible to do or even to consider doing.
Why?
Don't you think the jurors are sitting
Now, wait a minute. Let's before you answer that question of
why didn't you test the guy and tell us where it's been?
Well, the answer is because every case that's done asks you about retrospective information. There's never an opportunity to come in and do it. First of all, taking a blood sample is an invasive procedure. It's something that can only be done by a physician. Say again?
You see what I'm saying? I mean, how do you deal with that?
he's saying you have access. you can have your defendant sent to a physician, a phlebotomist or whatever, draw the blood, have it tested any way you suggest.
It's not in the defendant's interest to have that done. So there's no reason to do it. I mean, that's the answer. No, if it ain't broke, don't fix it. A lot of people want to do follow-up testing, or shall I get this analyzed somewhere else? Some of those results could come back and be worse than the results you have to deal with.
But I think, in response, it's their burden, not ours. And if you understand that part, you can understand we don't have to do anything more than what we just did.
Yeah, sure, but you think they
Just one thing, I think he's
you
misunderstanding.
had to come up, where you had to deal with that issue. I'm just trying to figure out how we deal
No.
with it. I hire him, and then I gotta deal with that issue.
I don't know, man, I think he's misunderstanding the fact that.
Go ahead.
He's dealing with an expert testimony here who's not contesting the defendant, he's contesting the machine.
That's right. He's contesting the theory of the machine, but in furtherance of, but he's also qualified to testify as to the significance of 1 to 2100 on the human sample, and he's saying, you can't tell us whether it was 1 to, the cross-examination would go something like this. You could just as well be 1 to 1400. Do the numbers based on 1 to 1400, and you have an overly low reading. And it can work both ways, and that's the type of cross-examination you can anticipate, and he'll deal with it.
Right. For example, if you said to me, well, you said the range was from 1 to 1500 to 1 to 3100. If it's 1 to 3100, that means it's about half as much. If it was 1 to 1500, it'd be twice as much, right? I'd say, yes, that's correct. But there was no evidence that that person had a 0.3 blood alcohol level instead of a 0.15. I mean, if you have some questions that you feel that would be worthwhile in a simulated cross, come and ask them of me, because it'd be beneficial for all of us.
Well, I think I'd ask you, do you ever meet the defendant?
Right. No, I didn't.
You have examined the defendant,
No, I haven't.
so you can't tell us what his ratio is, can you?
No, I cannot.
You could have, couldn't you?
Had I had the opportunity to do some actual testing, I could.
And you worked with the defendant, isn't that true? For Mr. Zisson, the defendant's attorney?
I did work for Mr. Zisson, yes.
It's possible that Mr. Zisson could have brought his client to you and had him tested, isn't that true?
It's true.
And we, in the jury, would have known what his ratio is.
Had I been asked to do that, and with the cooperation of his physician and under the right circumstances, we could have determined that information, yes.
But you did not.
No, we did not.
So you have no idea what his,
And neither does the Commonwealth or the machine.
I think the attack, by the way, if you think about it in terms of the per se law, forget about the fact that whether or not he was under the influence. The issue is the significance of that number. And if you can attack the assumption of that machine, and that is, the assumption of the machine is that person is 1 to 2100. It's no different than a life table. A life table means that everybody's born on the same day, dies on the same day. We all know that that's true, isn't it? Okay?
Now,
So-
another analogy that I use sometimes in court is, this is an average. And an average means that, for example, if you measured 100 people, you took all the numbers, added them together, and divided by 100, you come out with an average, or a mean. Now, if you could use the mean to extrapolate to each and every person in the population, every man would wear a size 42 suit, and every woman would wear a size 7B shoe. That's why using an average may be fine as a general proposition, but it doesn't give you specific information about an individual in each individual case. And that's the problem. Using an average is like making a generalization that's an ethnic slur.
Okay, and I know that many of us have various opinions about how and when to use these experts and how to attack it. We are confronted right now with buckling under to a number. And we've always put off, we can explain away an 08, 09, 10 in an ordinary OUI case. But if this is a per se case, the issue is whether or not he had a 0.08 or above in his blood at the time. This type of evidence is very compelling if we don't know. If we don't know. They would have to bring somebody in to say, Borkenstein used to testify in these cases. He started it all. This is Dr. Borkenstein from University of whatever it is.
Indiana, down in
Yeah.
Indiana.
And you see his name all over the place. And he put out a paper at one time that said that a certain percentage of the population that had a high blood-breath ratio would have false highs. But if he was asked the rest of the question, what about the percentage of the population that have low, which would be giving false lows, he would answer that question, and it would hurt you. It would really hurt you, because, in fact, if you look at that graph that is in the materials at some point, you'll see what we're talking about. It's irrelevant. The point is, we're not trying to, the Commonwealth cannot, with just the machine, speculate on what that number is if they can't make that machine more reliable. That's your argument. That's your argument. You're attacking the number based on the machine. We're not talking about gas chromatography where they draw blood and they have a chain of custody and they do it correctly with the logs and all that stuff. Different ballgame. Different ballgame. But we're talking about a machine and a computer chip and a machine that can be overused, as testified to by the president of the company, if you do more than so many tests a month. And it's unreliable under these circumstances, but reliable under these circumstances. They have certain mouthpiece issues. There's all kinds of materials out there if you want to take the time to look at it. Fortunately, you don't have to. You have somebody else to testify to these things. But what you're doing is you're attacking the reliability of the number.
Oh, wait, but just hold it 1 second. I just want to add one quick point. Now, just remember, we're using the extremes. Those are exactly the extremes, the variability from the low of 1 to 1,500 to the high of 1 to 3,100. But look at the simple math. As Dick pointed out earlier, both repetitive breath tests have to be within 0.02 of one another. So there really is an intrinsic, I said that there was an intrinsic 6.5% in looking at the CalCheck. There's an intrinsic double that of about 13% maybe in the 0.02. Also, if a person blew 0.10, you only need to get that number down 21%. You need to get that you need to go from 0.1 to below 0.08 to be below the statutory level. So 20% off of 100 or off of 0.1 is 0.08. So you only need to come down 21% from a 0.1. You need to come down 11% from a 0.09. So what I've given you are the extremes. But when the numbers are smaller, the amount of variability. And one good follow-up question, Dick, on the experts direct would be, now, doctor, you told us what the extremes would be, 48%. But if my client blew a 0.1, how much variability would be required to get him below 0.08? And the answer is 21%. You don't need 48%.
Judge.
I think you have to keep in mind, too, many jurors who we see believe in this whole infallibility of the breathalyzer. I'm always amazed how many cases in which the jury is deliberating all of 5 or 10 minutes and the court officer comes and says they have a question, and it's, did he take the breathalyzer? In cases in which the breathalyzer was never mentioned, has no bearing, the jurors, unfortunately, believe in its accuracy and its reliability. That they see it as an infallible test. So any type of evidence that you can proffer before a jury which questions the whole accuracy of the machine, I think is invaluable. I don't see the average juror getting caught up in the math part of it, and I understand that you do have to establish that in making the case. But, you know, the point that the gentleman in the back was making, I think it's a valid point. But at the same time, as a defense attorney, your standard is to establish some reasonable doubt. And so I would suggest that by merely calling the expert in the vast majority of cases, you're going to be able to plant that seed.
I think I have one question on that.
Yeah.
For you as a judge. It occurred to me when I was asking the question, am I calling on the defendant who...
Right. Are you calling on the defendant? Right. Right. I think you know the answer to it, and I think you're absolutely right that you are. You're shifting the burden. Why didn't the defendant go to you? Why didn't...
I wonder with an expert, could the prosecutor push that limit?
Well, what you're saying is, inferentially, where is that evidence we could rely on? Otherwise, they would have brought it up. They didn't have to bring up anything.
Right.
Okay, so you have the same issue as...
I wonder with a judge, would the prosecutor be given that little bit of leeway, whereas as an expert?
I think it's on very treacherous ground, so...
In the way you profited, I think I can help you out. In
Yeah.
the way you profited, I think you'd have a problem. On the other hand, There's nothing wrong with he's rendering an opinion. He's not a recipient witness. There's nothing wrong with asking him, but you don't know what this ratio is, and giving hypotheticals to the expert. What if it was this number? What if it went to 1,500? What if it went to 1,600? You have to do the math 15 different times. You can drive him crazy. But that and try to muddle or neutralize what he had to say without saying you had access to him. Why didn't you have him take a blood test? I mean, I don't think that.
I mean, as a defense lawyer, I'm just looking to hedge, so
Yeah.
Yeah, the way to cry, and I know there are some prosecutors here, and they're learning by this, and they're probably going to be able to do that. But the reality is, he can raise about 15 different points, and I didn't go through all of them, but 15 different points individually and slowly and methodically about why that can impact the reading on the machine, other than the 2100.
Mr. Zissin, have you found it better with jury waves or jury?
Depends on the judge, okay? I know what the answer's gonna be before I go jury waive. That's all I can tell you. I know pretty strongly.
And
as
I
much
will-
as they might deny it, because let's say you lose, it's an OUI second. What do you tell the client? At least this way, it's a jury of their peers. I'm very hesitant in jury waive, unless I am very comfortable after a lobby conference, and we've all done it, so we know what we're talking about.
I will tell you that every bench trial in which I've testified, whether it's been on this OUI or using other types of scientific data to talk about variability, the judges have always found in favor of the client that I was retained to help. Every time. I've never had it not go in the way
Did you
of
bring cards with you today?
a lot.
Okay. Anyone else? I mean, this is.
Judge, on the fourth offense, it gave you a not guilty?
Well,
Nelson.
you know, a lot of the times I
Hold
don't
on,
know.
one at a time.
I'm sorry.
Go ahead. Did you ask a question, Dennis?
I just facetiously,
No, we can save that for discussion later. Go
I
ahead,
don't know
Nelson.
I don't know how many offenses and.
I think the gentleman back here makes a good point insofar as assuming you can get away with it, as to the impact of the jury, that is whether or not you ever did any blood testing. So I'm just wondering whether or not, in anticipation of that kind of thing, it might not be appropriate to ask the police officer whether or not the police department took a blood sample. You're gonna know in advance. He says no, and in argument, you can argue to the jury.
Now, Massachusetts, there's a statute on blood. Unless, in other places, New Hampshire, it's different. They have phlebotomists up there in Maine.
That's right.
But in Massachusetts, you can only draw blood forensically under the statute with the consent, with a trained this, and the statute is very, very narrow.
The question would be, did you ask the defendant if he would give a blood sample?
Did you offer an alternative to the breath test?
Yeah, and he says no. And that way, you could at least argue to the jury.
That's a good point.
Right?
Right, because you know the decision is ultimately the defendant's. Does he want to give up a sample of blood or she want to give up a sample or not?
Exactly.
Right.
That way,
That takes the onus off of me as if I was not complete in my workup.
Right.
Now, Kevin Reddington had the OUI case, and he did a superb job with the experts that he used. It wasn't necessary to use a toxicologist in that particular case. But how would you comment on the use of experts? Can you overuse experts? Or in this particular circumstance, do you actually need an expert for that 08?
I would think that on the cross-examination, you might be able to raise the doubt on the 08 and the reliability of the opinion, depending on, all the factors, obviously. I mean, again, it's just like I said earlier, building the house. I mean, the client's got to have the money to retain the expert. You got to have the money to, some experts come from out of state. I mean, where do you stop? So it's really a decision that has to be made based on what the client is able to pay. I think it's based upon the evidence that you get in discovery, based upon your opinion as to what you can damage on cross-examination and raising a reasonable doubt. But the short of it is that, yeah, I would prefer to have an expert on a breathalyzer case if available.
Anyone else? Yes, sir.
So if you do have a breathalyzer, the correct sequence might be, instead of hiring an expert right away, is to
Right.
get the CMR regulations first.
Yep.
See if the machine is okay.
Yep.
And if the Commonwealth can get over that hurdle, if the
Yep.
machine is in good working order,
Right.
and they've done all the testing, et cetera, then you go out and get Mr. Demers. I'm sorry. Dr. Who?
Smith.
Never mind, just,
That was Bob Chase.
oh, no, it's the younger people, the New Hampshire guy that was used, all,
The main guy is now in
Maine,
Virginia,
he was
and he
from
still
Maine.
comes in.
boys from New Hampshire at the beginning.
All right.
No, he was from Maine.
Anyone, yes, sir?
Just one thing to reiterate what Kevin says, whenever you have a breathalyzer and the client says, do we mount a defense, the next question is, do you want to pay for an expert?
Yeah. Well, I think that the whole calculus has changed with this per se law, okay? Before, you could argue the impairment, because a lot of people walk around all day long with a 1.5 in their system, they're fine. So they're not impaired, because they're drunks, and they can function, okay?
Right.
That's not the issue. With this no law, you're forced to attack the number, not whether or not there was impairment. So that takes away an opinion case and puts it into what's called an ascertainable fact case. And in order to attack an ascertainable fact, you have to have something. And I don't see any way around it. The problem is, it's a function of money. And could you ask a judge, as private counsel, for money for an expert if there's a compelling reason with affidavits of indigency or whatever, and that he had to borrow money for this? I don't know what a court would do. I know that resources are tighter now than they've ever been. I don't know what this court would do, but I've heard it argued, and I've heard it asked for, and in some circumstances have been allowed. Not necessarily a breathalyzer expert, a breath test expert, but investigators or things of that sort. I don't know what the reaction with your court would be. You have if for a compelling reason, in
For a
other words.
compelling reason, I definitely, where's Judge Roof?
I'm sorry?
For a compelling reason to,
Doctor was telling me about alcoholism.
a motion for funds for an expert.
Assuming there's private
Or a-
counsel, Judge, and there's and he borrowed his last dime from his brother-in-law, and he can't get another dollar, and it's clear that he's indigent on other factors, but he wants private counsel. Would that be enough of a reason, if you have a case with a per se issue?
I would say that I would have that person interviewed by probation again, because the financial condition now has changed. And that at least gives us a foundational basis to make a semi-indigency determination if the Commonwealth's gonna pay. What comes to mind is how on appeal, even with private counsel, the rule of criminal procedure allows us the Commonwealth to pay the cost of transcripts, even if the person's not indigent. It's one of those peculiarities in the rules of criminal procedure. So in order for me to expend the Commonwealth's money, I would want to have some backup, namely the probation intake, where now we know that this person's financial condition has changed to the extent that they don't have any available funds. But if they have, $300,000 in equity in there, each.
That's different.
Now we're in.
We wouldn't be asking. We're not talking about that kind of a case.
Right.
We're talking about the kind of a case where the person would qualify as indigent, but for a loan from a relative of
So
some.
that's why the probation intake would allow me then to allow that kind of motion up to $3,000.
Okay. Yes, ma'am.
So you're saying you would allow private counsel to continue to represent the person and give us state funds to retain an expert?
Yes, that's what we're talking about.
Not in all cases.
Right, in an extreme case where a person
Yes.
would otherwise be indigent.
When it married,
Right.
yeah.
Right, for one of them.
Yes, sir.
We've done it for, if I could just, I know I've done it for investigators. But again, it's in compelling cases, and the defense attorney has done his or her homework and has shown that there are no other resources.
Under
Last question, and then we're gonna take a
the,
very
under the
limited
old law,
break.
we used to attack the liability for breathalyzer motion, and somebody from the Commonwealth would be the expert on the machine. Now, what you're saying is now, because of the per se, that should be done at trial. And if does the Commonwealth have to produce an expert witness? And are there treatises that we can use to impeach, to basically elicit Dr. Benjamin's information from the Commonwealth?
Well, that's a very interesting question. Are we entitled to a Daubert hearing, notwithstanding what the statute says? George, what do you think? Based on what the doctors told us,
As to the admissibility of the breath test
as its
result?
reliability.
I haven't seen any, on the expert thing, I think the defense counsel has to look for a way to do it on cross-examination. I think the reality is, just as Kevin said, you know, people aren't gonna have the dough. I think there is a way to do it on cross where you can knock out without the.
That's why I'm asking, can we use his information?
I think it's gonna be the manual from the police department, the officers' training, because if you go through that breath test motion, they take actual written tests, they receive certifications, and they have to have a full understanding of the working of the machine. I think we can go at least on cross as to the 2100 to 1, and you tie it in with your jury instruction as to, when you ask that question, you don't know, officer, you were the operator, and you understand that this machine is based on an assumption, and that assumption is that it's 1 to 2100. And you understand that's just an average. And you learned that in your course, didn't you, officer? And in that course, you also learned that not everybody's a 2100 to 1. And you don't know what Mr. Jones is. He could be a 1 to 3100 to 1, correct? So not knowing, so that's not a specific reading as to Mr. Jones, is it? That's an average, isn't it? Now, if the court agrees to instruct, as I've requested, that the Commonwealth has to prove beyond a reasonable doubt that it's this person specifically had a .08 or above, I think you've got an argument right there just on the cross, because I haven't used an expert on a breath test in probably, I think I've used one once in the last 8 years because of the number of breath test cases I've seen. But because of the impact of the statute, I've probably had 7 come in the office just since the change of the statute, the number of the increase in breath tests. So I haven't challenged the reliability. The last time I challenged the reliability, I lost on appeal, and the case, it was Commonwealth versus Kelly, and I think Kelly is going to be is not good law any longer. I think now we're going to have to become a strict compliance state where it's small things that the Commonwealth doesn't have in the breath test can no longer be referred to as ministerial in nature, but that we're going to be a strict compliance, and if you do your homework and you get everything, and there's one item out, for instance, the certification for the simulated solution is not in the possession of the individual police departments. It's only in OAT. And as I read the Code of Mass Regulations, in order for the admissibility of a breath test to come in, you need that certification of a simulated solution. Kelly said, that's ministerial, it's somewhere, you don't have to worry about it. Boy, it's strict compliance. I think a DA, in order for everything to come in, has to have certification of the operator, certification of the machine, certification of the simulated solution, certification of the rules of the maintenance and repair logs. And if you're missing one cert, then strict compliance.
That's right.
That's out.
That's right.
As we stand now. So strategically, how far do you want to go? Do you want to stop producing those records? Do you want to ask the government to produce them for you? I think it's a real strategy decision. I think
it's in the motion.
It's in the motion.
What I did is I tracked every CMR, anything that has a piece of paper attached, and I want it. And they're required to keep it, and I want it. One of the most difficult parts, and they've solved it, is a few years back, they were using, because they didn't have time to do gas chromatography, is they were testing the solution with a breath test machine. Just like the tail wagging the dog. And they have to use gas chromatography. They have to have their own rules and regulations. They have to promulgate them. They've got them. The problem with it is anytime a difficulty arises, Nancy Burns can change it. She can change the CMR. And the bottom of a boiler room someplace, there's a notice saying there's a public hearing on the change of the CMR. Next thing you know, it's changed. So, and then she's done it several times. I'm saying that respectfully. This business about truncating the last number was as a direct result of a couple of motions that I filed. Because if you look at, it says .02, you don't know if that's 155 solution or 15 solution. If it's 155 solution, and the lower number could be down to a 14, you don't know if it's 141. That goes beyond the tolerance. She changes the reg.
And she wrote us out of that motion.
Yep.
Because it was a good motion. Judges were allowing it. The test doesn't come in. And Nancy Burns wrote us out. She changed the CMR, and it's down to the 2 digits now.
In statistics, anytime you're working with statistics or numbers, you can only use the variability of the least reliable figure, and that's a 2-decimal mode. And that's why a point, for example, 15 blank could be 0.15, 1, 2, 3, 4, 5, 6, 7, 8, 9. It's still the first 2 figures are just 0.15. So you can only use the number of what we call significant figures. You don't round it off, you truncate. So you can only use 2 significant figures because that's the limit of the variability of the smallest change that can be measured.
What I'd like to do right now is take a 10-minute break, not 15, but 10. If you folks will be back here at 20 of, we'll start with the closing arguments, and then we'll have a discussion about the rest of the course. And
But I
we'll talk
think
about the machine.
we're entitled to the Dover hearing. I think if you ask for it, I think we should get it under the, if they're proceeding on the per se violation.
I think, are you entitled to Deauville where the statute specifically allows, in other words, inherently reliable, goes to weight, not admissibility? I think if the statute says a 2-test protocol, breath test machine, all these certifications, CMR complied with, even if it's unreliable. If we can prove it's unreliable, it's still in, because you can get a statute.
I'm not sure. I think what you could do to get the hearing is if you had somebody like Dr. Benjamin, you file your motion, and he files an affidavit with much of this information in it, then you might reach the level where you've raised the issue, so that a judge could sit there and say,
The judge is the gatekeeper under that.
Right,
He would have
the
to,
gatekeeper.
and now you've put all,
That's what the statute says, that's our, not the statute, that's what the
Dover
case is
says.
saying, Dover and Lanigan.
Yeah.
Massachusetts.
Lanigan and Massachusetts, yeah.
Yeah, so we're still, the gatekeepers. They
So we
still
could
have to
theoretically
show
attach that-
reliability and relevance.
yeah, I think we could do it.
I agree.
Yeah, with this guy, I think I could. If you saw the, I don't know if you saw the materials from New Jersey, they were talking about fantastic stuff. When you read it, you say, my God. And there's all these little attachments you can put on the machine to do it,
Yeah, I
solve it,
know,
which they
all
don't
these
have.
variables, and that's all you know someplace in New
Yeah.
Jersey, is the fact that there's variables,
Yep.
and that this isn't infallible.
Judge, this is Alicia Thomasina from my
Hi,
office.
how are you?
This is Judge Coffey.
See you.
Yeah, she just started working for us about 2 or 3 months ago. Yeah.
Is this your first job? That is so
No, she clerked for the probate court. She wrote the decisions for the judges.
assisted them.
Assisted them, right. Have you learned something? Because I have her in the, she's never done a criminal case. So I have her in the court every day on these miscreants that I represent.
That's good. Now, do you do divorce too?
Oh, yeah, do a lot of divorce. A lot of high-asset stuff. The criminal stuff, yes, yeah. It's worked out.
Now, how much did you have work?
And we got 12. We have
Do you still have Roberta Kenny? She's
Oh, no, she's the, Roberta is the personnel director of the city of Quincy, corporate counsel. She's the head honcho. She's terrific. She's terrific.
Yeah, I know. She was
Yeah.
so delighted when you hired her.
Yeah. She's terrific. No, we have an office on the Cape and about 8 or 9 lawyers down there. I've lost track. My partner's down there. And I'm up here with 2.
I'll show you the table.
And, it's worked out. Yeah, one's on maternity leave right now.
Yeah, and where on the Cape?
And Dennis on 6A, Cape Playhouse. Nicer in the summertime. You gonna leave? You want to get out of here, really? Oh, are you? Okay, good. What's that? Oh, that you're gonna take the phone My wife likes to take it with her girlfriend, that fun wild bus.
I just heard about it.
Yeah, they get out, they go to plays, they stay at the Edison Hotel, and they go to the
I
theater.
just heard about this. Yeah.
Yeah, nice one, quick question, sure.
You know, the judges, I think, not to give us any.
One way, where are you?
Why? Chelsea. You see, that's another Chelsea. I don't get funds from it. They always get say, no. Funds from it. That's the upfront. You need to think about whether or not that point away. Question for
Parrot answers that test. You point the parrot at the beak, go like that, push your button, the parrot.
Would you tell Tom about
They
this? I said,
over-regulate
yes.
by making
I'm so
all
glad you
this
did. I hope
stuff.
he's treating you well.
Even validity from a 40-hour course. And they gotta learn something out of it. And the assumption is that you have to be certified with this really.
You don't have a sheet like foundation. The difference between
That's right.
Pull out the materials. Did you learn such a thing? You learned this, you learned that. That there's a range to be.
I'm not making this up.
There's something in here. I don't know if you put the whole thing. Some stuff in here. Some of the stuff. That's right. This is the. You put it in there. It's a price. The doctor had it.
I'm so glad you said that. Yeah, he's
Officer of Here's the machine. Those are the ratios.
Ask him,
That's the 1 to 1500. That's the 1 to 1900. 1 to 2000. You're supposed to learn all that. You gotta read it. You gotta learn it. That's the problem. You have to know more than finding this thing in Florida.
I must have baked it. It took me and she tried to keep me. Give me a continuance. My case gets called 11:30 in the morning. Yeah, 11:30 in the morning. So you go to work. I had to tell him I used to work with him. He said, okay, we could judge Ford. So I go to Judge Ford. We don't know. Oh, he was prosecutor. That's how she thinks. So I go there and she says, okay, I'm going to handle your jury at 2. Come back at 2. I come back at 2. We're doing closing arguments. Jury charge. 10 minutes to 4. She says, okay, ready for the jury? I said, I want to continue. She goes, why? You answer ready for trial? I said, yeah, I answer ready for trial at 9 o'clock. I told you, Your Honor, I had that seminar on Friday. He says, I'll never be able to do it. So you can do it in 1 day. I've never done a trial in 1 day. What about they deliberate? Please continue my case, Your Honor. And she finally did. She finally did. I really had I know.
That's right.
I asked that same question about weight the other day down the warehouse. So the same guy was overweight. I'm trying to comply without citing my client. Isn't Mr. So overweight? I don't think so.
The material.
It helped me. It was a not guilty, but I mean, it was obvious the guy was fat. I didn't want to use the word fat. They don't really It's actually about the same description of this thing. He's good.
Great job, by the way. Beginner's luck, right? Is he
5'9" and 240 pounds?
He's a good kid.
I think I'm looking at myself because my father's always calling me over there. Oh, my father.
Garrett Prego is his supervisor.
No way.
Oh my God. Yeah. We're 2 of them. Garrett's biggest fans.
You hired the expert. The expert will Okay. Okay, folks, can we get started, please? Everybody sit down? Thank you. We're going to have closing arguments in this particular case, and then we'll have a presentation by Dr. Benjamin on the machine. And at that time, you can ask your questions about the reliability of the machine. So I'm going to call upon, since the defense goes first, I'll call upon Mr. Reddington to persuade you with his eloquence.
Tough act to follow, especially knowing that Dr. Benjamin is going to be speaking again. Okay. Members of the jury, you've heard the case. It was a very brief period of time. It certainly wasn't a lengthy trial, but no question that it was an important case, certainly for all the parties concerned. I think that one of the things that you carry away, hopefully, from your opportunity here to sit here is to determine that you may have a snap judgment, you may listen to an opening statement, you may make an observation about a witness, and then you may, after you've had a chance to see cross-examination or consideration of the evidence, you may then say, well, you know, my initial observation really was not right. And you might then weigh or consider your opinion. And that's the whole idea. That's the beauty of a trial. And the beauty of the trial, and beauty of the jury system is that any defendant, any citizen who's charged with a crime has the opportunity of appearing before people like you. And that those people pass between, as the clerk said in the ancient language, pass between the Commonwealth of Massachusetts and the defendant. And the defendant places himself on his country, which country you are. That's what the clerk said in the very beginning of the case. Probably don't remember that, but it's so significant because you are not part of the Commonwealth. You pass between the government. You pass between the prosecutor. You pass between all of the police officers and all of the might and the power of the Commonwealth. And you determine whether or not the government has proven the case beyond a reasonable doubt. Your Honor will instruct you on what that heavy burden of proof means. Your Honor will tell you that the burden of proof is on the government. It's right here on the government. The government has to come into court with evidence that you collectively determine as a jury, after you've had a chance to weigh it, consider it, draw your inferences, drawing on your common experience, drawing on your lifestyle, drawing on the people you know, your education, your background, your friends, your family, using all of that experience to determine whether or not the government has proven, well, you know, it sounds more probable than not. Or, you know, gee, I think it really is a pretty good guess. Or, you know, well, that's what I think, or it's probable. No, not in a criminal trial. Proof beyond a reasonable doubt. Now, what does the government do? They bring a very, very fine young officer in. He did a great job. He's out there that evening, 28 degrees, 2:30 in the morning, on a roadway where nothing's happening. And he's sitting in the car with the heat on, obviously, because it's cold. And he's got his winter outfit on, as he indicated. And he's on one side of the street, which is a pretty good stretch of road. It seems to be a little bit of a kind of a high performance area, perhaps 45 miles an hour running through the town and nothing's happening as he's sitting there with the other police officer on the other side of the road, running a radar gun. Now you can draw inferences from the evidence and drawing on your common experience. 2:30 in the morning, what do you think is happening when along comes Mr. Oxtein, who's driving along at 82 miles an hour? Now, at 2:20 in the morning, you may say, wow, that is a high rate of speed. And if you're a police officer, you may really have a little bit of an attitude about it, and you might figure that, well, you know, they should have an attitude about it. It's 82 miles an hour. But when I asked the officer, and it's your memory, not mine, but when I asked the officer, you make an observation of this car is coming, you observe the car coming, it does not go over the lines, no. You observe it go past you, doesn't go over the lines, no. No erratic operation, no. But he immediately, according to his police report, plus his testimony is he did not immediately take the soup, and in the report he does agree, he then pulls out behind the vehicle and follows the vehicle for a significant period of time. Now, as a citizen, if you're charged with a crime, you're stuck with the evidence that the government has. They don't take a video. They don't have photographs. They don't have independent corroborating evidence that would be of some type of reliability. No, what they have is the police officer's testimony and the other backup police officer to testify to what the other guy makes an indication as to what his memory may be. And how does he determine his memory? Well, he's got notes, but we don't have the notes. He throws the notes away, or the notes are destroyed. Okay. Well, he comes into court and he can testify based on the skillful direct examination of the government counsel, and government counsel asks him all these questions. Where did you go? What did you do? Who did you see? What do you think? What's your opinion? And then the government rests. Well, then we get up on cross-examination. And you see that it is 28 degrees that night. It's not cool, it's cold. It's below freezing. You see that the police officer has got his outfit on and he's dressed for winter travel. You see that there is literally very modest operation of that vehicle that would justify a police officer pulling it over, other than the 82 miles an hour. And I would argue to you that, quite frankly, the vehicle was operated in a decent fashion at 82 miles per hour. No question the guy's speeding. Police officer follows him, at least for a half a mile. You have to remember that, right? Because he said that, well, I had my lights on, he didn't pull over, I followed him for half a mile. He does not know what distance we're talking about prior to the half a mile. I asked him, could it be a half a mile? Yeah, so we got, on balance, proof beyond a reasonable doubt. Not my problem to prove to you how many feet or yards or miles, the police officer followed Mr. Oxton, it's the government's burden. But in any event, so let's say for a mile, he pulls his vehicle over what? Once and then back. You gotta be kidding me. Police officer with not another car on the road except for the other cop running the radar is behind this vehicle at 80-something miles per hour. The guy only pulls over to the right once. You don't think he was pulling over, let the cop go by him? And then he lights him up, puts his takedown lights on, puts his blue lights on, and the guy pulls right over. After half a mile, looking in the mirror, he pulls the vehicle over appropriately, backs the car properly parallel. Police officer approaches. He notices no difficulty pulling over, no difficulty asking him for his license and registration, a strong odor of alcohol coming from the interior of the vehicle. Ask him for his license and registration. He produces his license and registration. Ask him to get out of the vehicle. How lame is that they say that, well, he had difficulty getting out of the vehicle? Everybody will hold on to something, touch something as you walk, and especially a guy of his size. Look at the size of him. As he gets out of the vehicle on a cold night, this objective police officer won't even let him get his jacket. What is this, a security issue? He won't let him put his jacket on? He's gonna stand there with his leather on. The other guy's got his leather on. It's 28 degrees out. He's getting out of a warm car, and he can't even put his overcoat on. Objective? What did you do? Did you drink that night? Yeah. Where did you drink? What did you drink? 12 ounce, 16 ounce. No, it didn't matter. Can you believe that? It doesn't matter. No, it doesn't matter because as far as he's concerned, he's got a guy doing 82 miles an hour. He's going to cite him for speeding. He's going to cite him for OUI. But you see, that's where it stops. Because he's not out on the road of that town anymore. He's in a court. Burden of proof beyond a reasonable doubt. Do the alphabet. He does the alphabet. He stops at D, big deal. Officer did indicate that you can have a brain cramp, you can have nervousness, you can get thick tongue in dealing with people when you're in trouble like that. Man's driving at a high rate of speed, he's got to lose breath, obviously, he knows he's in some trouble there. But what does he do? He stops himself, corrects himself, stops at D, goes back, starts, all the way through the alphabet, appropriate, sequentially appropriate, but says it methodically. What does that mean, methodically? Wouldn't you do it methodically? If you're out there and dealing with a police officer and you're going to say the alphabet, you're not going to say it, you're not going to say it quickly. And he says, what do you think of that? And he says, that was belligerent. Think about that. In all other aspects, the man was cooperative and working with the officer, and all he says is, what do you think of that? Is that nervousness? Is he just trying to, make a joke? Hey, what do you think of that? No, it's belligerent. But yet, he still had an open mind. After he says the alphabet, he asks him to do it. I'm going to read the sequence. Police officer wrote a report. Initially went with me on a different sequence, but that's all right. He then asked him to do the finger to the nose test. He asked him to do the finger to the nose test. He asked him to do the one-legged stand. He asked him to do the 9-step walk and turn. He asks him whether he had an injury, and the guy says, no, he didn't have an injury. But you have the medical records to show that the man had an injury. He has a torn ACL. Goes back to football days. Didn't hurt it in the Marine Corps when he was in the service. He hurt it when he was playing football. Nevertheless, he still hurt it. And there's testimony that that can impair the person's ability to stand on one leg. It can impair the person's ability to walk the 9-step walk and turn. So you have the speech, which can be impaired through nerves. You got the glassy eyes, which can be impaired from cigarette smoke or whatever. You got the odor of alcohol that he doesn't say continued. He doesn't say in the police cruiser it continued. He doesn't say that in his talking to the defendant it continued. He says it came from the interior of the vehicle. You don't know what he had to drink because he doesn't really take the time to make a note of the specifics of it. You don't know where, what, or when. You're left with speculation and guesswork, and then it goes even further. He asks him to do the 9-step walk and turn. He does the 9-step walk and turn. He does it quite well. Heel to toe, no problem. Counts out loud, no problem. Sequentially appropriate, no problem. Turns, and he says that he had some unsteadiness when he turned. These are not things that people do on a daily basis. These are not things that people do. You don't walk like this. And you don't turn like this. If you did, somebody would look at you like there's something wrong with you. Especially when you've got 2 police cruisers, blue lights going, 2 cops in uniform, in their leathers, and you're out there freezing at 28 degrees in the wind on a roadway. So, on balance, I would just ask that you listen to the judge's instructions, and when you consider the fact, as Your Honor may instruct you, that 2 equally inconsistent propositions do not amount to proof of anything, let alone proof beyond a reasonable doubt.
When you listen to it that way, it sounds like the deck was stacked against Mr. Oakstein from the very beginning. My brother would have you believe that the police officers had a speed trap set up solely for the purpose of catching unsuspecting individuals like Mr. Augustine. But when you look at the facts, an individual is not going to be caught in a speed trap unless they were, in fact, speeding, which is what took place on this night. On March 1st, the defendant was going 82 miles an hour in a 45-mile-an-hour zone. And yes, luckily, Officer Sheehan took note of that, observed it, and began to follow him. And on following him, he saw that he also went back and forth across the lines. Now, he didn't follow him for an extended period of time. He followed him long enough to think there's something going on here. This guy's traveling at a high rate of speed. He's going back and forth over the line. I'm going to pull him over. He put on his lights. He put on his siren. And about half a mile later, the defendant pulled over. Now, I said at the beginning of this trial that you'll hear evidence from the Commonwealth with respect to the field sobriety tests that were administered and the manner in which the defendant failed those tests. And you've heard that evidence from Officer Sheehan with respect to the alphabet test, the finger-to-nose test, the one-legged stand, the 9-step walk and turn. And I also said that you'd hear another side of the story. You'd hear evidence and you'd hear excuses. And you've heard a number of excuses today. You've heard smoke and mirrors for the most part. And to think about it, you'd think from what was going on, at least from the way my brother tells it, that it was almost a disco club with the two different cars and the lights and sirens going, wind blowing back and forth, and it freezing all this time with poor Mr. Augustine standing at the side of the road conducting these field sobriety tests. Well, let's take a look at the field sobriety tests, but also at the circumstances surrounding those tests, because the field sobriety tests, while they are in fact the heart of the Commonwealth's case, they're not the entirety of the Commonwealth's case. From start to finish, we have an individual traveling at a high rate of speed, exhibiting to the officer in a posted speed zone a lack of judgment, an inability to follow the directions of the road, a clue to the officer that something might in fact be wrong. When the officer pulls over Mr. Augustine, he asks him for his license and registration. He also asks him, did you have anything to drink this evening? And the defendant admits candidly and cooperatively, and as I said, he's a good man. Absolutely nothing nefarious about Mr. Augustine, simply made some bad choices on that night. Some of those choices which included having a few too many drinks before getting in his car to drive. But he candidly and openly admits to the officer that he had a few drinks that evening. He had a few beers with dinner. You've heard he had 3 beers with dinner. Now, this is at 2:30 in the morning. Remember, the officer testified that there was a strong odor of alcohol coming from the car when he first rolled down the window. Now, you've heard this about a vacuum theory and how it all comes up, and certainly you can take that into consideration. And in your own experience, you might have experience with someone rolling down a window, and perhaps you'll smell perfume or smoke or whatever the case may be a bit more strongly when the window first rolls down. But that's not all we have. Because remember, when the officer administered the field sobriety test, the alphabet test, that strong odor of alcohol was no longer coming from the car, it was coming from the defendant's mouth. And he smelled it very strongly. In addition to a strong odor of alcohol, the defendant's eyes were bloodshot, they were glassy. Well, again, something that my brother would excuse through the smoke in a bar room, or perhaps the wind in his eyes, or perhaps the weather, perhaps an allergy. Who knows? But you begin to put 1 and 1 together, and you come up with 2. And in this case, the officer had bloodshot eyes, glassy eyes, slurred speech, a strong odor of alcohol. And when he asked Mr. Augustine to get out of the car and perform some field sobriety tests, he fumbled. He leaned, and while each and every day many of us may lean on something, add that together with the other observations that the officer made. This is an individual who was not able to maintain his balance, an individual who couldn't follow simple directions, who had to be asked twice to provide his license and registration. Was he cooperative? Absolutely. The Commonwealth at no time contends that the defendant was uncooperative. Perhaps inappropriate at times, as the officer testified when he completed, at the second opportunity, the alphabet test, and said, what do you think of that? What all might consider perhaps an inappropriate response. If in fact he was nervous at being stopped, and many of us would be nervous at being stopped for potentially driving under the influence of alcohol, certainly an understandable response. And if that were all that the Commonwealth brought before you, I would suggest to you at this point that your verdict should be a not guilty. But that's not all that we have. What else is there? Failure of the alphabet test, slurred speech, odor of alcohol, red glassy eyes, loss of balance. We get to the finger-to-nose test. And again, the officer, who's got plenty of experience, 10 years veteran on the force, performed a number of these tests before, explained and demonstrated to the defendant, who seemed to understand what he was being asked to do, to touch his nose, touch his finger to his nose. He gave him 4 opportunities to do this. Well, 25% isn't bad, if you look at it that way. But that's what the defendant did. 1 out of 4 times was he able to comply with the instructions. 1 out of 4 times was his motor coordination sufficient to complete the task he was asked. One-legged stand. Well, I move back and forth. Probably think it would be difficult even for me to stay in one place at one time and hold my leg up for 30 seconds. You've heard a number of excuses as to why the defendant couldn't do that in this case, why he hopped up and down or leaned against his leg, why he bounced back and forth and lost his balance. Anything from the medical records, which you've heard about in this unrepaired ACLU tear, which, by the way, didn't appear to have stopped him from serving his country. And that's a good thing. As I said, he is a good man with a good job who served his country valiantly as a Marine. It stopped him from being able to stand on this one particular night, although it didn't stop him in doing much else in his life, especially when the officer asked him if you had any medical conditions or if you're on any medications that would prevent you from performing these tests. At the time, he said no. In fact, the officer gave him the opportunity to use either leg. And he chose to use that very same leg, which before you today you hear is the subject of an unrepaired tear that makes it impossible for him to stand on that leg. Even in the best of all possible lights, if that were the case, then on that particular evening, it's just another example of poor judgment that Mr. Oxtein exercised in choosing the wrong leg to stand on, if he in fact knew that that leg was a problem. And he loses his balance.